ගරු එම්.ඒ. සුමන්තිර මැතිතුමා ඔබතුමාට මිනිත්තු 21ක කාලයක් තියෙනවා.
Thank you, Chairman of Committees. Often when I have spoken on the Ministry of, on the votes of the Ministry of Justice, I have likened the Minister of Justice in this country to the Minister of Port and Shipping of Afghanistan. வளமையாக நீதி அமைச்சு சம்பந்தமாக பேசுகிற போது ஆப்கானிஸ்தானுடைய கப்பல் போக்குவரத்து மற்றும் துறைமுக அமைச்சரை போல தான் இந்த நாட்டிலே நீதி அமைச்சர் இருக்கிறார் என்று நான் சொல்வது வழக்கம். இந்த தடவை அப்படி சொல்லாமல் இருக்கலாமோ என்று நினைத்தால் கடந்த சில நாட்களாக இந்த நாட்டிலே நடந்த பல விடயங்கள் இப்பொழுதும் நீதி இல்லாத நாட்டிலே ஒரு நீதி அமைச்சர் என்று சொல்லித்தான் இந்த பேச்சை ஆரம்பிக்க வேண்டியதாக இருக்கிறது. நீதி இல்லாத நாடு என்று நான் சொல்லுகிறதற்கான பிரதானமான காரணம் நாட்டிலே சட்டங்கள் வெவ்வேறு மக்களுக்கு வெவ்வேறு விதமாக பிரயோகிக்கப்படுவது அப்பட்டமாக தெரிகிறது. அது நாங்கள் சுட்டிக்காட்டக்கூட தேவையில்லை. கடந்த சில நாட்களாக வடக்கு கிழக்கிலே மரணித்தவர்களை நினைவு கூறுகிற அந்த உரித்தை அந்த மரணித்தவர்களுடைய உறவினர்களும் நண்பர்களும் மற்றவர்களும் உபயோகப்படுத்துகிற போது அவர்களுக்கு ஏற்பட்ட சங்கடங்கள், நீதிமன்றங்களை போலீசார் நாடினார்கள். நீதிமன்றங்களும் போலீசாருடைய கோரிக்கைக்கு இடமளித்து பழக்கமாகிவிட்ட நீதவான் நீதிமன்றங்கள் பல இடங்களிலே நீதவான்களுக்கு என்ன செய்வதென்று தெரியாமல் திக்குமுக்காடி கொண்டு கூட இருந்தார்கள். குற்றவியல் நடவடிக்கை சட்டக்கோவையின் 106ஆம் பிரிவு வேறு வேறு காரணங்களுக்காக சட்டத்திலே கொடுக்கப்பட்டிருக்கிறது. இப்படியான விடயத்துக்கு அல்ல என்பதை பல ஆண்டுகளாக நானும் இந்த மன்றத்திலேயும் சொல்லி வருகிறேன், நீதிமன்றங்களிலேயும் சொல்லுகிறோம். ஆனால் நீதவான்மார் பயப்படுகிறார்கள், அதுதான் உண்மை. அதற்காக உரித்து இருக்கிறது என்பதும் அவர்களுக்கு தெரியும். ஆனால் போலீசாரையும் ஆட்சியையும் பகைக்கவும் விரும்பவில்லை. ஆகையினாலே வேறு சில தடங்கல்களை போடுகிறார்கள், நிபந்தனைகளை விதிக்கிறார்கள். அந்த குறித்த சட்டம் இப்படியான ஒன்றுக்கு பொருத்தமே அற்றது என்று சொன்னால் அதை கண்டுகொள்கிறார்கள் இல்லை. இந்த தடவை கிளிநொச்சி நீதிமன்றத்திலே மட்டும்தான், நீதவான் நீதிமன்றத்திலே மட்டும்தான் 7 போலீஸ் நிலையங்கள் செய்த விண்ணப்பத்துக்கு இந்த சட்ட ஏற்பாடு இப்படியான நிகழ்வுக்கு பொருத்தமற்றது என்பதை நீதவானே ஏற்றுக்கொண்டு அத்தனையையும் புறக்கணித்தார். மற்ற எல்லா நீதிமன்றங்களிலேயும் சில நிபந்தனைகளை விதித்தார்கள். இது பொருத்தமற்ற ஒரு ஏற்பாடு என்பது எல்லாருக்கும் தெரியும். பொருத்தமற்ற ஏற்பாடு என்றால் அதுக்கு கீழே இப்படியான விண்ணப்பங்கள் செய்ய முடியாது. ஆகையினாலே இப்படியான ஒரு சூழ்நிலை, நாட்டிலே சட்டங்கள் வெவ்வேறு மக்களுக்கு வெவ்வேறு விதமாக உபயோகிக்கப்படுகிறது. கொழும்பிலே ரோஹண விஜயவீரனுடைய படத்தை அவர் சீருடையோடு தொப்பியும் அணிந்து செல்லுகிற படத்தை வீதி வீதியாக கொண்டு செல்ல முடிகிறது. ஆனால் தங்களுடைய இறந்த உறவினர்களுக்கு நினைவு கூறுவதற்கு பலவிதமான நிபந்தனைகள். ஏன் இந்த நாட்டிலே 2 விதமாக சட்டங்கள் பாய்கின்றன? இது இனங்களுக்கு மட்டுமல்ல, இடையிலே மட்டுமல்ல, சமயங்களுக்கும் இடையிலேயும் இருக்கிறது. I read yesterday that Pastor Jerome Fernando has been arrested and remanded also, and the magistrate has made certain comments while remanding him, while Sumanaratna Thera from Batiklo has been making speeches openly saying that he will cut Tamil people to pieces. He has not been arrested, he has not been remanded, he is considered to be above the law. So this is the curse of this country, and I think the Minister of Justice must be ashamed to call himself the Minister of Justice. If you held another portfolio, you can just pass off. But how dare you call yourself Minister of Justice in this country when there is no justice? So blatantly discrimination is apparent, and I think it must be a burden to you to go around the world calling yourself the Minister of Justice of Sri Lanka. In this house, there are questions that have been raised. Now, these are fundamental issues. This house has freedom of speech. Everyone knows that. Not only this house, parliaments world over have that privilege. And that is given for a reason. Without exception, parliaments around the world have that privilege. It is wrong to say that someone here is speaking under cover of privilege. No, that's a wrong phrase. It's not cover of privilege. He is using his privilege because the law has given him that privilege. Historically and universally, that's a privilege that is given for a very good reason. And when that is used, it's wrong to say somebody is taking cover behind privilege. Now, this is a fundamental issue. Honorable Leader of the Opposition raised it today. Honorable Chief Opposition Whip raised it today. At first sight, any application made to court must be dismissed without even a hearing. That's how the committee relationship between the three organs of government must be maintained. Otherwise, Section 3 and 4 of the Parliamentary Powers and Privileges Act will become useless. That if lawyers have to go, if parties have to appear before court and argue and convince judges that they have no jurisdiction. I mean, this is a blatantly fundamental position. It ought not to be entertained. But that doesn't seem to be the situation in this country anymore. That expressions in the House here are being challenged. I don't want to go into specific cases because then we will ourselves be violating tradition of principles of sub judice and all that. So I don't want to do that. But it's a worrying factor. This is certainly a matter that must worry all of us as to the relationship between these organs of government. Now I want to come to something that happened in this House on the 24th of November and the 26th of November. On the 24th of November, His Excellency the President came into this House and he read from some determinations of the Supreme Court, and he asserted that the Constitutional Council is part of the executive. And then I spoke that day, soon after his speech, but he thought it was best that he does not remain in the House when I spoke. He left. 2 days later, in an afternoon, he comes into the chamber here, when I am not here, and then he replies me. And then he leaves again. When the opposition leader asked him to stay, he gets up and goes away. Now, what did he say? He said, 17th Amendment to the Constitution has established the Constitutional Council as a part of the executive. That is wrong. He said that he, Honorable K.N. Choksi at that time, and someone else, Honorable Karu Jayasuriya, drafted that law. That is also wrong. That was at the insistence of the Janata Vimukti Peramuna at that time in 2001 that it was brought. He was talking about something else. He was talking about the 18th and the 19th Amendment, the aborted 18th and the 19th Amendment, which was never passed in this House, which during his tenure as Prime Minister, he brought to clip the wings of the Executive President at that time. He was reading from those determinations and claiming that they were part of the 17th Amendment determination. He even said that Honorable Sumandiran appeared in the case and for Center for Policy Alternatives, I was bemused because in 2001 I was not in the country. I was reading for my master's degree elsewhere. But having looked at the documents, 17th Amendment to the Constitution, this is what it says. Chief Justice Sarath Silva's bench, when he gave the determination, it says, I'm reading from the parliamentary, the decisions of the Supreme Court in parliamentary bills, which is a publication of the parliament. I'm saying all this because I'm reading from authoritative text, unlike the President. At page 250 of the volume of decisions between 1990 and 2003, and it says the Constitutional Council is being established. And it says, in that respect, the provisions relating to the establishment and functions of the Constitutional Council is a core of the 17th Amendment. These provisions are contained as noted above in the new chapter 7A, and that is where the leader of the House was also wrong on that very day. He rose in this House and he said the Constitutional Council appears under the same chapter as the executive. That is wrong. There is a new chapter created. Executive is chapter 7, a new chapter 7 capital A is created. Sua generis organization, Constitutional Council is neither part of the executive nor part of the legislature. On that day I made an intervention. I did not say it was part of the legislature. I said it was part of the legislative structure. And that is what the 17th Amendment determination also says. I later found out. It says, is a core of the 17th Amendment. These provisions are contained as noted above in the new chapter 7A with articles 41A to 41H. The Council is essentially a body that comes within the aegis of Parliament, with the Speaker as its chairman. With the Speaker as its chairman. That is why it is part of the legislative structure. Speaker is a chairman, the body always has met in Parliament. But that doesn't make it part of the legislature in the strictest sense of the word. In the part that His Excellency quoted, which is actually the 18th Amendment to the Constitution determination, which appears at page 306 of the same volume, there is a statement that this is the executive power. The reason for that is the 18th Amendment bill. Honorable Minister of Justice, Honorable Vijayadasa Rajapaksa also appeared in this case. I also appeared in the matter, and I distinctly remember your submissions in the Supreme Court then, which was primarily aimed at the language. I remember you saying, this is bad English. How can this be part of our Constitution? Something that was the President claims he and Honorable Choksi drafted. Right? Hurriedly drafted perhaps. It says the Constitutional Council established under the 17th Amendment is part of the executive and is attributed executive power for the reason they were considering the rules that were to be made part of the Constitution for the Constitutional Council. Constitutional Council determinations were sought to be taken away from the jurisdiction of the court and was sought to be made immune from judicial proceedings. It is in that context that the court said this is the exercise of executive power by the President. Restrictions are placed on his exercise of executive power, and therefore those decisions must be subject to judicial power. It is the exercise of executive power that is sought to be restricted. So that is what we have been saying. It's a check and balance on the executive power by a body that is separate from the executive, that is separate from the legislature, but is under the aegis of the Parliament. Now, unfortunately, these have to be placed on record, because otherwise it goes unchallenged. Some people ask me, are these the more important things in the country today? Well, perhaps not. But when the President comes here and says what he wants, half-baked arguments when nobody here is to challenge what he says, and then he gets up and walks away, it's important that we put him right. The same determination says the Constitutional Council, as pointed out earlier, is established by the 17th Amendment. Proposed amendment enables the Council to exercise legislative power. Why? Because they can make rules. It's subsidiary legislation, no doubt, and they said that it must have the approval of Parliament, but something of the legislative power, because they can make subsidiary legislation by means of rules. Now, with regard to the relationship between the executive's power, which has been curtailed by the Constitutional Council, that must have some meaning. 17th Amendment was brought for good governance. The determination recognizes that. It was sought to be taken away by the 18th Amendment, brought back by the 19th Amendment, taken away again by the 20th Amendment, brought back by the 21st Amendment with a lot of fanfare, saying that we are bringing this back. But you can't say we have brought back the check and balance on the President, and that the President behaves as though there is no check and balance, that he is the be-all and end-all of all, that his nomination must be accepted. I will make only one nomination and that must be accepted. No, that is wrong. That is not the intention of Parliament when it enacted these amendments 3 times over to curtail the untrammeled power of the executive president, and that must be noted, because now we have come into a situation of another crisis of governance. This has an implication for economic recovery as well. This has been highlighted by even the IMF, and the President is the one who is violating the Constitution. I am saying it a second time in this House in less than a month. This is intentional violation of the Constitution, an offence for which he can be impeached. With regard to privilege, I want to again put this on record. The Standing Order 83(1) only prohibits the personal conduct of various persons, including judges, from being matters of reference in this House. Previously, the Standing Order said the conduct. That was changed. Previous Standing Order 78 said the conduct cannot be subject matter of discussion. Now that has been restricted to personal conduct. That's with a good reason. It's this House that gives judges judicial power. In fact, judicial power is exercised by Parliament through courts. And to that extent, Parliament has an obligation. It is true, for judiciary to act independently, we must restrain ourselves. We don't discuss matters sub judice. We don't discuss judges' personal conduct. But we certainly can discuss the official conduct of judges. And not only here, even outside, we can subject decisions of court to scrutiny and criticize it. That must be there for a vibrant democracy, but it must be exercised with caution so that the independence of the judiciary is not affected. These balances seem to be coming under attack, and to that extent I want to ask the Minister of Justice, who is a member of both organs in a sense. He is a member of the Inner Bar, a very senior President's Council, and now he is part of the executive, occupying the position of Minister of Justice, and to ensure that we continue to maintain these balance carefully and not allow one to step on the toes of the other. Thank you.
අවසන් බොහොම ස්තුතියි ඔබතුමාට. ඔව්.
ඔබතුමාට කලින් කිව්වා නඩුවක් පැවරු පළියට අධිකරණයෙන් නෝටිස් දෙන්න බෑ කියලා. නෝටිසේ. දැන් මම ඒකට උදාහරණයක් දෙන්නම්. මේ ළඟදී 15 අධිකරණවල විනිශ්චයකාරවරු නඩුවක් දැම්ම ඒ අය මේ ආණ්ඩුවේ අධික බදු බරවල නිදහස් කරන්න කියලා. අධිකරණය ඒක බලලා නෝටිස් දෙන්න නැතුව නඩුව ඉවත් කෙරුවා. ඩිස්මිස් කෙරුවා. The judges of the lower court filed an application to exclude them from this very high tax regime. The court rejected it, even without noticing the Inland Revenue. දේශීය ආදායම් බදුවකට කැදවන්න නැතුව නඩුව ඩිස්මිස් කෙරුවා. දැන් පාර්ලිමේන්තු මන්ත්‍රීවරයෙක් පැහැදිලිව තියෙන නීතියේ පාර්ලිමේන්තුවේ කතා කරපු නඩු දාන්න බෑ කියලා විනිශ්චයකාරවරු නඩු තිබිත්තක් තියෙනවද කියලා නෝටිස් කෙරුවා.
හොඳයි කරුමන්තුමා. ගරු විජේදාස රාජපක්ෂ.
Athanayakathumani, I am not going to talk about that case. That is a matter of sub judice. But the legal principle everybody knows. The court also has to follow the rule of audi alteram partem. That if the other party is not heard, the Honorable Sumantiran himself goes and argued in so many cases audi alteram partem. Anyway, now Honorable Sumantiran said that the president comes and he says whatever he wants and go. That is true. When the president wants to say something, he comes from that door and he says whatever he wants, he goes. Similarly, Honorable Sumantiram, when he wants to say something, he comes from that door and he goes back. What is wrong with that? And my concern is, Honorable Sumantiran said that I must be ashamed to be the Minister of Justice in this country. Certainly that if it came from a mediocre, that's, I will not be surprised, so I will not talk. But when it comes from a President's Counsel with a seniority like Mr. Honorable Sumantiran, I think that it is rather shameful to make a comment of that nature, because you cited three examples. One is that the magistrate in Northern Province has issued an order not to have rallies or protests, and as a result police has arrested some people. You yourself know what is the role of the Minister of Justice. Is this House by any statute given the power for the Minister of Justice to overrule the magistrate order? And you said about the monk's story. He has made some hatred speeches. Can the Minister of Justice go and arrest him? If anybody is affected, that it's their duty, his duty to go and make a complaint to the police, that the police has to act upon it. On the privilege issue, Honorable Deputy Speaker, that I didn't speak for any of the sides. Normally, when you file a case, you don't go to the judge. Parties are not allowed to have access to the judge. You go to the registrar. Then the registrar has to accept the plaint or the petition. After that, he has to give a number. Then only he will send it to the judge. Then it is the practice, inveterate practice during last 2 centuries in this country. Then thereafter, of course, when the other party appears, they are entitled to take up any objection, even they can ask even the notice to be recalled. In how many cases Honorable Sumantiran has appeared and made such applications? You know that I know. We have enough experience. But we have to be truthful in this House. We have to be truthful.
On that, why are they being arrested under PTA?
This is not about the determination. We were talking about this privilege issue.
No, I'm asking about the other matter, about why is the government not making a direction that the police not use a PTA?
බොහොම ස්තුතියි ඔබතුමාට.